everyone, and welcome to Daily Newspaper Analysis, which is brought to you by LawSikho. So today, this analysis will be discussed on basis of two articles. The first article is from the Indian Express and the Hindu. And let's see, the first article is a collage of laws that leaves the worker out in the cold. So this article has been taken from the Hindu newspaper, which talks about protecting and providing universalized social security system to all the people in the India, especially the ones that need it the most. And in the times of this pandemic, how these social security norms should be brought under one umbrella in order to give the maximum benefit to the people in need. And the second article is from the Indian Express, which is titled as Why United Kingdom's Cairn is Suing Air India in New York. So this talks about the Cairn versus Air India case. So what is this case all about, and what are the future of this case that can be seen by the Indian stakeholders has been discussed in this article. And finally, we have the News and Flash column. So this newspaper analysis is presented to you by me. My name is Sheva Khan, and I am a law graduate, completed my law degree in the year 2019 from Uttaranchal University with a batch gold medal. I have been a national debater and a public speaker throughout my educational career. And here at LawSikho, I'm currently working as the current affairs expert and manager for free content and outreach. If you wish to connect with me, you can definitely have a look at my Twitter as well as my LinkedIn IDs. The link to both the handles is given in the description box. Also, as a matter of small announcement, if at all, guys, you're facing any kind of issues in the background voice, please note that the weather here is taking severe turns, and that is why it has been raining incessantly, so it's beyond my control. So I really hope that it is not something that is disturbing you to get the grasp of this analysis. Anyway, let's get started with the MCQ from last day's discussion. Your question is, West Bank, recently seen in news, is in. So which country is in? Your options are Egypt, Israel, Iran, or Sudan. If you know the answer, please put your answer in the comment section below. This is a descriptive question of the day. In times as hard as this COVID pandemic, universalization of social security norms can be a good solution. Critically discuss. Let's get started with the discussion of a first article of the day, which talks about universalization of social security. So this article says that the pandemic has rendered low-paid informal workers, which were approximately 91% of the workforce, totally helpless into poverty and without a social security system, and also in the absence of any free basic care in public clinics and insurance. Now, as we know that the situation of the formal and informal workers in the India was already not very good. Now, by formal and informal workers, we mean that the formal workers are those that are completely recognized. The work done by them is completely recognized in the economy, and thus they're able to avail various kinds of benefits. Now, these benefits can be, for example, the DA, the TA, and the allowances, the rent allowances, health insurances, maternity benefits, etc. But unfortunately, in our country's economic system, a large workforce already used to work as informal workers. Now, for example, if you see a person who's pulling a rickshaw, do you think he gets himself registered somewhere to do so? Or if there is a person who has a very small pawn shop, so do you think that he would have registered his entire business under any company or something? Absolutely not. So these all people fall under the ambit of informal workers. And the pandemic of COVID-19 has actually brought these informal workers, and due to which these informal workers, which were approximately 91% of the total workforce, have been brought into complete abject poverty, and that too without any kinds of social security systems. Let's discuss that what is the Social Security Code of 2020 that has been discussed in this article. So the Social Security Code of 2020 merges or brings together all the existing social security laws and attempts to include informal workers within the ambit of social security. Now, obviously, when we talk about the various kinds of social securities, so it is these informal workers who need them the most. And that is why the Social Security Code of 2020 proposes that we should bring together all the social security laws and attempts and bring them all under one umbrella to give a convergent and to give a focused benefit to these informal workers in the society. So it amalgamates 8 existing central labor laws such as the EPF, the ESI, maternity benefits, gratuity, etc. So like we have the employees provident fund, then we have the employee state insurance, etc. So all these things have been proposed to be brought together so that a kind of convergent and a better benefit system can be drawn out for the informal workers. Secondly, the code proposed that the government will formulate schemes for unorganized workers who has to get mandatorily registered. So the government will come forward and it will formulate various kinds of schemes for these informal workers for the benefit of these informal workers, and the workers which we are talking about here who are the informal ones will have to mandatorily, compulsorily get themselves registered so that they come into the government accounts and the government at least knows in the first place as to who and how many are the beneficiaries of their schemes. Because currently there is a lack of awareness among the informal workers in the first place, and secondly, the informal workers lack digital literacy and connectivity and find it difficult to furnish all the documents required, due to which basically due to these basic, but when they become very important for places like these or for things like these, due to these things, they ultimately have to drop out from various kinds of government benefit schemes, and ultimately the benefits of the government schemes which were actually designed to percolate and to reach these informal workers, they are never able to reach them in the first place. Okay, so the code does not provide for interstate cooperation. All right, this says that here one thing that is a problem with this code, that it does not provide for interstate cooperation, and holistic security cover is lost in the center state tussle. What happens is that, as we know, when we talk about the workers, let's take the biggest example of migrant workers. So why we call them as the migrant workers is because they move from one state to another state, from one city to another city, from the rural to the urban areas. So in a way, whatsoever be the reason, whatsoever be the system, whatsoever be the direction, the migrant workers move. Now, in such a situation, it is ideal and it is definitely important that there is cooperation amongst the states so that a smoother delivery of these benefits can be taken place. But due to this, if at all this element is missing of having the interstate cooperation, what happens is that the holistic security cover is completely lost in the center state tussle, because many a times it becomes very confusing for the center or the states or even amongst the states as to who has been given the benefit, who has not been given the benefit, and due to this movement of the workers, especially the informal workers, the entire purpose of this particular law or the vision is defeated. Now let's discuss that what are the key benefits of the code. Firstly, the provision of maternity benefit has not been made universal, which is applicable to established with 10 workers or more. So here, this actually talks about the point of having the maternity benefit, wherein it says that it is currently applicable to only the established workplaces that have 10 workers or more. And thus here the ambit might be increased to a greater extent. Secondly, the Employees Provident Fund is still not applicable to informal sector workers, which are established with less than 20 workers, and that is why the people over here are tend to be exploited. But definitely this code will be able to give them better, in a way, resources, and in a way a better EPF funds as well. And thirdly, the payment of gratuity, which is there after the retirement, was expanded but limited to established with 10 or plus workers only, which will be actually resolved by this particular Social Security Code of 2020. Now, here are also some problems with the code that have been highlighted in the article, wherein it says that it remains a collage of laws without any integration. Now, if you understand why at all we are calling it as a collage, so back in school when we were, just young students, if you remember, we used to have many times these competitions of making or designing a collage. So what we used to do was that we can pick up bits and pieces of different colors and from magazines, newspapers, etc. And we used to paste them on one larger piece of paper, bringing out a whole and bigger picture. But always what used to happen was that the demarcations or the separations in those pasted pieces of papers were always evident. Similar is the analogy that has been drawn in this particular article regarding the Social Security Code as well, that even after integrating such social security norms and laws in the country, it still remains out to be a collage of laws without any real integration, which means that they appear to look together, but they still look different from each other. And that is why better integration and a smoother blend has to be seen in the future. And secondly, it puts extra financial burden on the states without a doubt. Yes, obviously, when we talk about providing maternity benefits to all, the gratuity benefits to all, EPF, ECI, and other labor benefits to all the people in the country or all the informal workers, definitely it will have a huge toll on the financial health of the entire state system. So if at all we talk about that, what are the various social security laws in the country? So let's take a few examples. Like we have the Employees Provident Fund Act of 1952, the Labor Welfare Act of 1965, the Payment of Gratuity Act 1972. Then if we talk about the wages, we have the Payment of Wages Act 1936, the Payment of Bonus Act 1965, the Minimum Wages Act, the Equal Remuneration Act. Then for various industrial laws, we have the Industrial Dispute Act, the Trade Unions Act, the Factories Act, etc. And for the benefits of women, especially in the times of maternity, we have the Maternity Benefit Act, and otherwise we have the Equal Remuneration Act. Then we have the Sexual Harassment of Women at Workplace Act 2013. So all these are the various important labor laws in India, which this Social Security Code 2020 seeks to amalgamate under one umbrella. With this, let's start our discussion for the second article of the day, which talks about the Cairn Energy Plc versus Air India case. So this case is an important one for us to study, wherein what happened was that recently the Cairn Energy Plc, which is a British oil company, is now suing Air India in New York to seize its assets in order to enforce a $1.2 billion arbitration award, which it has actually won against the Indian government. So let's understand into a small detail as to what was the dispute at all. So in the year 2006, the Cairn Energy transferred shares of Cairn India Holdings to Cairn India Limited. So the Cairn India Holdings was not an Indian company, please note. So it actually made a share of, the transfer of shares was done through this thing. Then subsequently, it divested 30% of its shares through an IPO, which was an initial public offering. So it actually sold out its 30% share through an initial public offering, and most of the remaining stake was sold, but the Cairn was not allowed to transfer 9.8% of its stake. Now what happened was that the tax authorities argued that the share transfers attracted capital gains of rupees 6,000 to be paid to the Cairn UK. So actually the capital gains of rupees 6,000 crores to be paid by Cairn, United Kingdom. Then, in the year 2012, after a ruling by Supreme Court in the favor of Cairn UK, the definition of transfer of capital asset was amended in the IT Act to retrospectively apply to Cairn UK transfer. Now, as we know that this problem of retrospective taxation has always been one for which India has been looked down at the global level as well. So we know that here also for a retrospective thing as well, the amendment was done to change the definition of transfer of capital asset in the IT Act. And then in the year 2020, International Arbitration Tribunal ruled in favor of Cairn and awarded it $1.2 billion in compensation. Now let's understand that why is Air India being sued in this particular case. So as per the Cairn, Air India is the alter ego of India and should be jointly and severally responsible for India's debts. And Air India is a wholly owned and extensively controlled by Government of India. Also, here the principal agent relationship also has been highlighted, and also it says that now the courts in US will have to determine the level of economic control of Air India by the government, and based on that the liability and responsibility of Government of India and Air India would be decided. Now, this entire case has also been challenged in different jurisdictions, like in The Hague. In the arbitration award was delivered in Hague. For New York, Air India's assets they were located there, and Cairn has initiated the proceedings in other locations too. So thus it has become a matter of international arbitration, and here this has again sprouted up the issue of retrospective taxation and the issue of principal agent relationship. With this, let's see what do we have for news and flash today. Infrastructure status for convention centers. The Finance Ministry has granted the status for exhibition and convention centers with an aim to ease the bank financing norms for such projects. The infrastructure tag does not involve significant tax breaks, but by becoming the MICE, which is the Meetings, Incentives, Conference and Exhibitions destination, it can generate significant revenue with several global firms active in India. So with this, we are done for the day. We hope it was a good session for you. Thank you so much for staying tuned with LawSikho. Please subscribe to our channel for such more updates to come.